what is concept of an assumed traverse or implied traverse, what is confession and avoidance, what is additional pleading, what is replication and rejoinder. Let us understand these concepts keeping with the provisions of the CPC. As far the pleading is concerned, Order 6 of the CPC deals with the pleading. Order 6, Rule 1 of the CPC says that pleading shall mean plaint or written statement. So therefore, only pleading means plaint or written statement. Plaint is presented by the plaintiff and written statement is always filed by the defendant. Now, Order 7 deals with the plaint. Though plaint has not been defined in the Act or the CPC, plaint is a statement of claim made by the plaintiff in his suit. And written statement is filed by the defendant in response to the plaint presented by the plaintiff. Order 8 of the CPC deals with the written statement. Now, Order 8, Rule 5 says that the averment made in the plaint, if not specifically denied by the defendant or there is a evasive denial by the defendant, then the averment made by the plaintiff shall deem to be admitted. So, now, Order 8, Rule 2 of the CPC says that the defendant to specifically plead new facts. He has right to plead new facts because it is provided under Order 8 Rule 2 of the CPC. Now, what is additional pleading? Order 8 Rule 9 of the CPC provides that no pleading subsequent to written statement of the defendant other than by way of defense to set off or counterclaim shall be presented except by leave of the court. Meaning thereby, the plaintiff can file the reply of the written statement only in case the defendant pleaded set off and counterclaim. But in case he want to file replication other than in response to counterclaim and set off, then leave of the court is required. Sometimes the averment made in the written statement are not clear. The court may at any time require a written statement or additional written statement, though there is no statutory recognition of the replication or the rejoinder in the CPC. So, in these circumstances, subsequent pleading or additional pleading which is permitted to be filed in the court, that is replication, which is a reply filed by the plaintiff in response to the written statement filed by the defendant, and rejoinder is filed by the defendant if he want to explain certain additional point raised by the plaintiff in his replication. If we read Order 8 Rule 5, it applies only to the defendant, because it says that the averment made in the plaint, if not specifically denied by the defendant, it shall deem to be admitted. Now, the theory of assumed traverse apply only to the plaintiff. Means, there is a presumption that the point raised by the defendant in his written statement deemed to have been denied by the plaintiff, because CPC nowhere says that if plaintiff does not reply to the written statement, the point raised by the defendant shall deem to be admitted. It is nowhere mentioned in the CPC. So the principle of assumed traverse will apply. Means, averment made by the defendant shall deem to be denied by the plaintiff. So there is no need to file replication in routine routine. Rather, it shall be filed or allowed only in case of confession and avoidance. Cases where point confession and avoidance here means cases where point has been raised by the defendant and the plaintiff admit the fact, but at the same time he want to avoid the implications that the defendant has tried to raise. Now let us understand these assumed tremors, avoidance and confession and avoidance by two examples or two illustrations. For instance, number one, if the plaintiff files a suit for recovery against the defendant and the defendant says that he had paid the amount or the claim of money raised by the plaintiff. Now issue will be framed and ultimately will be decided. But if the plaintiff admits, plaintiff says that yes, he has paid some amount, but that amount does not deals or does not relating to the claim made by the plaintiff and it relates to some other transactions, then in those circumstances he can, meaning thereby he is confessing, he is admitting that he has paid some amount, but he want to avoid its implications on the ground that it has been made with regard to some other transaction. Now he has to explain which transaction. Now replication is required. So here the plaintiff is permitted to file the replication. Now let us take the second example. In a suit relating to title to the property, the defendant denies and disputes the plaintiff title by setting up the plea of gift and adoption. If the plaintiff merely denies the gift and adoption, he need not to file any replication because it's deemed to be denied by principle of assumed tremors. But if he admits, yes, adoption is there, gift is there, but these gift and adoption are illegal on certain grounds, and illegality has been pleaded by the plaintiff by way of replication. Here, replication is allowed to be filed. Now, there is a distinction between the additional pleading and amendment of pleading. Additional pleading is something in addition to the original pleading. But amendment is substitution of some averment made in the plaint and it relate back to the date when suit is filed. So there is a difference between the two. If there is a right of amendment and some substitution is required, then he has right to file the amendment application under order 6 rule 17. Need not to file additional pleading. Now there are two landmark judgment on this issue. Sheikh Nurul Hassan versus and Inderjit Singh, that is 2024 judgment, and second is Anant Construction Company versus Ram Nivas, that is Delhi High Court decision 1995. Replication is always defensive pleading in nature. It is explanatory in nature. It comes under the additional pleading. It is by way of confession and avoidance or explanation of the plea raised by the defense. Now in these two judgments which I have mentioned, the Honorable Delhi High Court in Anant Construction Company versus Ram Nivas has summed up these issues which I have raised. The Honorable Delhi High Court held that replication and rejoinder have well-defined meaning. Replication is pleading by the plaintiff in answer to the defendant plea, and rejoinder is second pleading by the defendant in answer to the plaintiff reply to the replication. Second, replication to the written statement is not to be filed nor permitted to be filed ordinarily, much less in routine manner. A replication is permissible in three situations. Number one, when it is required by law. Number two, when counterclaim is raised or set off is pleaded by the defendant. And number three, when the court direct or permits replication to be filed. And court will direct or permit replication to be filed when having scrutinized the plaint and written statement, the need of the plaintiff joining specific pleading to a case specifically or newly raised issues in the written statement is felt. Such a need arises for plaintiff introducing a plea by way of confession and avoidance, which I already discussed. A plaintiff can seek leave of the court, or a plaintiff seeking leave of the court has to present before it the proposed application. Only applying its mind, the court may grant or refuse to leave. And fifth is, a mere denial of the defendant in case by the plaintiff need not to file replication. The plaintiff can reply on rule of implied or assumed tremors and jointer of issue. This principle can apply and there is no need to file the replication.